Hello everyone, welcome to Courts Today by LiveLaw, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines and a concise overview of the top stories, and after that we will delve into the full details. The Supreme Court has asked the Delhi Lieutenant Governor to file personal affidavit on illegal tree felling in Ridge Forest area and has sought action against the erring officials. The Supreme Court has expressed dismay that the states of Punjab and Haryana are extremely reluctant to act against stubble burning. The Bar Council of India has directed that private law universities are not authorized to use words like Indian, Bharatiya or national for moot court competitions or other competitions. Saying that a fugitive cannot maintain Article 32 petition, the Solicitor General has objected to Zakir Naik's plea in the Supreme Court. The Delhi High Court has sought Bar Council of India's stand on attendance requirements for 5-year LLB courses in a suo motu case over a student's suicide. The Delhi High Court has ordered takedown of Wikipedia page on pending defamation suit by ANI. And the Supreme Court is set to consider the question whether establishment of Gram Nyayalayas by states and union territories is mandatory or not. The Supreme Court today directed the chairperson of Delhi Development Authority, that is the Lieutenant Governor of Delhi, V.K. Saxena, to file a personal affidavit making a full disclosure on various aspects relating to the illegal felling of trees in the Delhi's Ridge Forest in February 2024. A bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra passed the order in the contempt case initiated by the court against the Vice Chairman of the DDA over felling of about 1,100 trees purportedly for the widening of the road. The court also said that it expected the Delhi LG to take steps to fix accountability on the part of erring officials, be it in the form of disciplinary proceedings or criminal prosecution by the next date of hearing. The court noted from the materials that the chairperson had visited the site on 3rd February and directed expedition of the road widening process. However, noting that the material on record was a little ambiguous, the court said that it needed certain factual clarifications from the LG. It has ordered that the chairperson must personally file an affidavit providing full details based on the available records and their own knowledge, especially considering what happened during the site visit. The affidavit should also explain what was done with the timber from the trees that were cut down and whether it has been recorded in the inventory. The matter will now be heard on 22nd October. Stay tuned. In the next update, the top court today pulled up the states of Haryana and Punjab over their failure to take action against farmers who are indulging in stubble burning, which results in deterioration of the air quality in Delhi NCR. Coming down heavily on the states, the bench comprising Justices Abhay S. Oak, Ehsanuddin Amanullah and Augustine George Massey directed the chief secretaries of both the states to be present before the court on the next hearing date. The court was displeased that the states have not taken any steps to implement the directions issued by the Commission for Air Quality Management, that is CAQM, in the NCR in June 2021 to stop stubble burning. It was noted that not even a single penal action has been taken by the state of Haryana as per clause 14 of the 2021 direction issued by the Commission. It directed the concerned authorities to take appropriate course of action against the officials of the state of Haryana and Punjab responsible for non-compliance. The court also posed questions to Additional Solicitor General Aishwarya Bhati regarding qualifications of members of the Commission, to which the ASG asserted that the Commission consists of experts in the field who are appointed after a rigorous process. Justice Oak suggested that it should engage with some expert agency to address the serious issue of air pollution. This matter will now be taken up on 23rd October. And now let me tell you, the Bar Council of India has issued a directive prohibiting private law universities from using prefixes such as Bharatiya, National, Indian, etc. for conducting moot courts or other competitions. The directive, however, clarified that these restrictions shall not be binding on national law universities or central or state universities which are affiliated to the respective governments. The directive cites provisions of the Emblems and Names Prevention of Improper Use Act 1950, which prohibits the use of certain names and terms, including those that suggest government or national patronage, without explicit permission from the central government. Section 3 of the Act prohibits any person or organization from using names such as National, Bharatiya or Rashtriya, or any name suggesting government patronage or professional or commercial purposes without prior approval. BCI's directive states that such a measure is being taken to prevent misuse of such titles, which had led to misleading practices in the recent past, despite institutions hosting these all India competitions not having the requisite authority to do so. It was further clarified that when the BCI hosts such competitions, they are authorized, since it is a statutory body incorporate for the regulation of legal education in India. Significantly, let me tell you, in another circular issued by the BCI, it has recommended that junior advocates be paid a minimum monthly stipend of 20,000 in urban areas and 15,000 in rural areas. This is following the direction issued by the Delhi High Court in July this year to take a decision on the monthly stipend for junior lawyers. The minimum stipend shall be provided for a period of at least 3 years from the date of engagement of the junior advocate. Acknowledging that there are considerable differences in the financial situations of advocates, the Bar Council of India said that it cannot make the guideline mandatory across the board. In another update, the Supreme Court today heard the writ petition filed in 2013 by Islamic preacher Zakir Naik seeking clubbing of multiple FIRs registered against him in Maharashtra and Karnataka for hate speech. Zakir Naik has been under investigation by the National Investigation Agency and the Enforcement Directorate for several years. He faces charges for promoting enmity between different religious groups and under the Unlawful Activities Prevention Act. A special NIA court in Mumbai had issued a non-bailable warrant against him in the year 2017. He has failed to appear before the court and is reportedly living in Malaysia. In the year 2022, the central government declared his Islamic Research Foundation as an unlawful association, citing that its activities were prejudicial to the sovereignty and security of India. Today, Solicitor General Tushar Mehta for the state of Maharashtra raised objection regarding the maintainability of the petition, stating that Naik is a declared fugitive by the court order and therefore cannot seek the remedy under Article 32 of the Constitution. On being questioned about the status of the cases filed against Naik, his counsel, Senior Advocate Aditya Sondhi, said that there are 43 cases in total. The Solicitor General informed the bench that a stay had been granted on the proceedings in 2013 and that an affidavit was ready but has not been filed due to defects in the petition. The SG pointed out that the petition is defective as per the registry and there are objections such as absence of Naik's signature. A bench of Justices Abhay Oak, Ehsanuddin Amanullah and Augustine George Massey allowed the state to file a counter affidavit to raise the objection regarding maintainability of the petition. The Delhi High Court has sought stand of the Legal Education Committee of Bar Council of India regarding the attendance requirements for 5-year LLB degree courses. A division bench comprising of Justice Pratibha M. Singh and Justice Amrit Sharma asked the committee to hold a virtual meeting for finalizing its position and directed that an affidavit be filed within 2 weeks. The court was dealing with a suo motu case concerning the suicide of Sushant Rohila, a student of Amity Law School, Delhi in 2016. His friend had written a letter to the then CJI alleging that Rohila was subjected to harassment by the college and some faculty members for maintaining low attendance and was forced to repeat an entire academic year. The Supreme Court had then taken cognizance of the letter petition and transferred the matter to the High Court. The union government informed the bench that following its last order, the UGC had sent a letter in September directing all higher educational institutes to form student grievance redressal committees as per the UGC regulations. However, the bench pointed out that the government's note did not include the outcomes of the 7th October consultation meeting with the statutory councils and UGC. The court then ordered the Department of Higher Education to submit a detailed affidavit listing all institutions that received UGC's letter and those that have responded. Next, the counsel appearing for Amity Law School said that Rohilla's parents were duly notified from time to time regarding the shortage of his attendance, and therefore the institution could not be blamed for his death. The bench then asked the council to obtain instructions if the varsity was willing to make ex gratia compensation to Rohilla's family. Senior advocate Dayan Krishnan, appearing as amicus curiae in this matter, submitted that there have been recent unfortunate incidents of suicides in different institutions. He sought permission to place on record a note to expand the scope of the consultation. Allowing the request, the court has listed the matter for hearing on 8th November now. In another update, the Delhi High Court has today ordered takedown of a page on Wikipedia on the pending proceedings about a 2 crores defamation suit filed by news agency Asian News International or ANI against the platform. ANI had filed a defamation suit against Wikipedia for allegedly defamatory content on its page, accusing Wikipedia of harming its reputation. The court had previously ordered Wikipedia to provide details of the 3 individuals who edited the page, but ANI claims Wikipedia failed to do so. ANI is seeking removal of the defamatory content and 2 crores in damages. The matter is being heard by Justice Naveen Chawla. Today, a division bench comprising Chief Justice Manmohan and Justice Tushar Rao Gadela noted that adverse comments were made against the single judge on the page, which was prima facie contemptuous. The Wikipedia page in question is titled Asian News International versus Wikimedia Foundation. It reads, "The judge in the case has threatened to order the government of India to shut down Wikipedia in the country." Earlier this week, the bench had taken exception to the page in question and pulled up Wikipedia, observing that the page will have to be taken down and that the single judge cannot be put in fear or be threatened. During the hearing today, Advocate Siddhant Kumar, appearing for ANI, told the court that after the last hearing, observations of the division bench were opened up for discussion on the page. The bench said that the description of the impugned order and of the single judge is prima facie contemptuous and amounts to interference in the court proceedings, and that too by an entity whose editors are defendants in the suit. Senior advocate Akhil Sibal, appearing for Wikimedia, submitted that neither the page wherein the impugned order was being commented upon nor the page on which discussion was opened regarding the observations of the division bench were created by Wikipedia. He also stated that in the event the court directs to take down the page and the discussions, the said order would be complied with. Accordingly, in the interim, the High Court directed that the pages on Wikipedia pertaining to the single judge as well as discussions of the observations of the division bench be taken down or deleted within 36 hours. The matter will now be heard next week. And lastly, the Supreme Court has today agreed to consider whether establishment of Gram Nyayalayas by states and union territories is mandatory under the Gram Nyayalayas Act 2008. A bench of Justices B.R. Gawai, Prashant Kumar Mishra and K.V. Vishwanathan was hearing a public interest litigation seeking the implementation of Gram Nyayalayas across the country. The court ordered that state governments must provide information consulting the Registrar Generals of the High Courts. This information must be submitted within 6 weeks. The court will be deciding if it is mandatory for the states to establish Gram Nyayalayas or if it is optional. For states that have agreed to establish them, the court will examine their progress in providing speedy, affordable and efficient justice in rural areas. The court also directed the Union of India to file a fresh affidavit on its compliance with a previous order from January 2020 and provide details on funds disbursed to state governments for Gram Nyayalayas. This 2020 order, let me tell you, had asked the union to consider increasing funding to 15 lakhs per year for 5 years with 50% state government contribution. For more information on the cases mentioned here, you can visit our website at www.livelawmedia.in. Stay ahead with quick legal updates only on LiveLaw. Please do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.